Welcome to CADRE's companion video to the Expedited Hearings section of the Parent Guide for the IDEA Special Education Due Process Complaints, also referred to as Due Process Hearing Requests. Parents or school districts may request an expedited due process hearing if they disagree about a discipline-related decision affecting a child's placement. This video explains what an expedited due process hearing is and how to file an expedited due process complaint. Expedited due process complaints are described generally for Part B of the Individuals with Disabilities Education Act, or IDEA. This resource is not intended to interpret, modify, or replace any procedural safeguards or requirements of federal or state law. An expedited hearing may only be requested in certain situations. This special type of due process complaint is used when parents disagree with the school district's discipline-related decision affecting their child's placement. Parents can also file an expedited due process complaint if they disagree with a manifestation determination decision. A manifestation determination is a decision as to whether a child's behavior that resulted in a discipline action is related to his or her disability. A school district may file an expedited due process complaint when it believes that a child's behavior could be dangerous to the child or others. Just like a due process hearing, an expedited hearing is a more formal process than other dispute resolution options. It is conducted by a hearing officer, who considers the information provided by each side, may ask questions of witnesses, and makes a decision about the dispute. The hearing officer is neutral and knowledgeable about the Individuals with Disabilities Education Act. A parent or public agency, such as your child's school district, may file an expedited due process complaint. This starts a process that may lead to a formal hearing where a hearing officer decides the outcome. After an expedited due process complaint is filed, your child must remain in the educational setting chosen by his or her IEP team until the hearing officer issues a decision or the time period for the disciplinary action expires, unless you and the school agree otherwise. This is often referred to as pendency or stay put. States may have different filing requirements and procedures for expedited due process complaints. Details on how to file an expedited due process complaint are available from your state education agency. Before filing, it's important to know that expedited due process complaints must include the same information required for a due process complaint. The IDEA requires an expedited due process complaint include at least the following information: the child's name, the child's address or contact information for a homeless child, the name of the child's school, a description of the specific problem concerning the child and the facts relating to that problem, and ideas or suggestions to resolve the matter. It is important to keep in mind expedited timeline differences, especially during or close to times when school is not in session, such as summer vacation and extended breaks. Before we share the expedited due process timeline, it is important to know the meaning of a school day and how that differs from a calendar day. School day has the same meaning for all children in school, including children with disabilities, meaning days when children are scheduled to attend school. Calendar day means all of the days on the calendar, including weekends and holidays. To begin with, a resolution meeting must occur within 7 calendar days of an expedited due process complaint being filed by the parent, unless the parent and the school district both agree in writing not to have a resolution meeting, or to use mediation instead. If the dispute is not resolved within 15 calendar days, the hearing timeline proceeds. If the hearing timeline proceeds, the hearing must be held within 20 school days of the expedited due process complaint being filed. The hearing officer must then issue a decision within 10 school days of the date of the hearing. It is also important to know that the hearing officer cannot extend the expedited hearing timeline. As with any due process hearing decision, the state education agency has the responsibility to make sure the hearing officer's decision is followed unless the decision is appealed. The state education agency must also share a copy, with personally identifiable information removed, with the state's advisory panel and make the decision available to the public. What happens if a party does not agree with the hearing officer's decision? Either party may appeal a due process hearing decision. For information on appeals in your state, check with your state education agency or parent center. It is important to know exactly how much time you have to appeal. In many states, appeals must be filed in a short period of time, such as within 30 or 60 calendar days after the hearing officer's decision. For additional information on due process complaints, expedited due process complaints, and resolution meetings, visit www.cadreworks.org/parent-guides. For state-specific information or individual assistance, contact your state education agency or parent center. The Center for Parent Information and Resources can also assist. They provide information on a variety of special education topics and a current list of all the parent centers in the nation on their website, parentcenterhub.org. To review the Individuals with Disabilities Education Act, visit sites.ed.gov/IDEA. This concludes the companion video to the Expedited Hearing section of the Parent Guide for the IDEA Special Education Due Process Complaints. We encourage you to also view the due process complaints videos as well as the other family resources located on CADRE's website, www.cadreworks.org/for-families.